which is always an examinable area. So go ahead.
So we did, for the trust versus other arrangements, we did bailment, an agency arrangement, contract. Yeah, basically. I'm trying to read directly from my notes. Yeah, that's all I have for now. Yeah.
Okay, Janice. I don't know. My volume is very, very low today.
Hello?
No, I said my volume is very, very low today. I don't understand why, but it's low.
Okay.
Yeah. All right. So, and then we also spoke last week about incorporation of a trust company and the different types of trusts, licenses that you can obtain. And we also spoke about termination of trust. So that's quite a bit you have to remember from the first lecture we had. So today we're going to talk about parties to a trust again, but in more detail. So who is a settlor? We mentioned it in the first class about a settlor. And the settlor is the person, recall what I said, has both the legal and equitable title in property. And that settlor, or could be called a grantor if he's granting a property, or he could be a donor if he's donating a property, has to transfer those assets to a trustee for the benefit of other persons or class of persons. If it's within a will, recall I said that if it's a male, it's a testator. If it's a female, it's a testatrix. And a trust is what you call an inter vivos trust if the trust is created during the lifetime of that settlor, grantor, or donor. And a testamentary trust is a term that's used for a trust that is created within a will. So the settlor has both legal and equitable interests. And when he creates the trust, he transfers that legal interest to the trustee. And the equitable interest is transferred to the beneficiaries, which gives them rights. So even though the settlor will be a client of the trustee, once the trust is created, he has no rights regarding that trust. The only way he'll have rights is if he is an actual beneficiary of the trust, or he has retained certain rights within the trust instrument. I think Ms. Dean would have sent all of you a copy of an asset trustee. Let me know if you received it. You did, right?
I did not.
I did not.
No?
No.
I tried calling her several times and to no avail. Did not.
Okay, I'm gonna send an email right now. Hold on 1 second, so we don't forget, because I gave it to them. Let me see, where is that? Right here. I thought you had it. Okay. Okay, it's gone. Okay, send a reminder. Okay, so the settlor, Once the trust deed is established, he can verify it or modify any terms of the trust. He can appoint trustees, he could remove trustees, and he could exercise his discretion in the payment of trust funds. He could even terminate. He cannot terminate the trust. He cannot do any of these things. So he can modify the terms of the trust. He can't vary it. He can't appoint trustees. He can't remove trustees. He can't exercise discretion unless that power is within the trust deed. So that's why I thought you would have had your trustee to look at it. So once you get it, you're gonna have to look at it after class. And then we could go through the sections in the deed. And he has to reserve these things expressly if he wants to exercise control over these areas, being mindful that he cannot have too much control. Because if he has too much control, then the trust will be considered a sham. Now, a settlor could issue letters of wishes to the trustee, where he sets out what he wants to do, how to manage it, how to administer it. But again, that document is not legally binding on the trustee. And if the trustee, based on the trust deed, has to exercise his discretion, he will exercise his discretion independently. And only way he would seek advice is if it is for investments or management of trust assets, or if there is a protector appointed in the trust deed. So again, the settlor only have rights if he is a beneficiary. And he would have contractual rights with the trustee, and as only as a client, and keeping his information confidential. Be mindful that as an equitable owner, a beneficiary has the right to sue. And that includes breach of trust. Now, a settlor, besides retaining certain powers within the trust deed, may appoint himself as a protector. And so when he appoints himself as a protector, his job then is to oversee and supervise the actions of the trustees. And depends on how that provision is made in the trust deed, he may also leave to himself the power to give consent to certain actions. And he may also be considered a power holder in his capacity as a protector. This means there are certain powers that are given to him that he has to undertake. Now, under our Trustee Act, we have something called a settlor directed trust. And you'll learn more about this when we discuss investments. So that means that a settlor can decide how he wants his investments managed. And by giving instructions to the trustee, it absolves the trustee from any lawsuit with regard to, I guess, mishandling of the trust assets, because they're doing it under his instructions. So a power holder, which is something that a protector would have, depends on the wording of the provision in the trust deed, is defined as any person holding a power in relation to a trust. And that includes a power of appointment, consent, direction, revocation, variation, or any power to appoint or remove a trustee. And that's why they call a power holder. So you see that the settlor himself, at the very beginning, when he sets out to establish a trust, he enters into a contractual arrangement with the trustee. And unless he retains powers within the trust deed, the only relationship he has with the trustee is a contractual one. He will have no rights and no powers under that trust deed unless he retains those. So you see that he can be a beneficiary, he can also be a protector, and he could also be a power holder. Any questions so far? No? Okay, so now let's move on to the trustee, which is the second person when we looked at the definition of what is a trust. So the trustee himself is a fiduciary. And remember, we said that a fiduciary is someone who acts on behalf of another person. And he does that in a position of trust and confidence. And once you're acting on behalf of someone else, it naturally arises by law that you have certain duties. And because it arises by law, it means that these are things that you must do. And the main one is you always have to act in good faith. And acting in good faith also means that you can profit from your position as a trustee. And you can put yourself as a trustee in a position where your duties conflict with your personal interest. Being a trustee also means that you're not paid for that service. So unless the trustee stipulates that you are to be paid, then you're not remunerated for your services. Of course, you can apply to the court. So the legal title for those properties were transferred to you as a trustee. So you are now the legal owner of those property. And with that comes rights, and comes duties, and you have obligations. Because as a trustee, recall that the next party in this arrangement are the beneficiaries who have the right to sue. And so you as the trustee now, whose responsibility is to administer and manage those assets. Your duty to the beneficiary is you have to preserve and protect that trust property. Because you now have that obligation to make sure that those assets benefit the beneficiaries. So the set law appoints the trustee when the trust is created. And during the duration of the trust, other trustees can be appointed. If the trustee dies, if they resign, they're removed, or they could be removed by the beneficiaries or by the court. Under a will, the trustees are appointed in the will. And remember that a will takes effect upon death, not while the person's living. So once you are appointed as a trustee, you have to carry out the acts that are stipulated in the trust instrument and according to the Trustee Act and its amendments and any other relevant legislation. So when he is administering the trust, he has duties and he has powers. And he has to perform his duties under the trust according to the provisions in the trust instrument and exercise his discretion when he's exercising his powers. But he must always act and exercise his discretion and his decision-making powers in the best interest of the trust as a whole and an equal and fair treatment of all beneficiaries. So as a trustee, because you're acting on behalf of other persons, and you have to do that in confidence, and you also have to do that in a position of trust, and automatically you have duties. And those duties arise in equity. And remember in last class, we spoke about equity itself. And we said that in the past, equity and its principles came from the maxims of equity. And we went through those maximums. So now looking at the general duties, he has to get trust property into the trust, which means that he has to get the legal interest transferred in the name of the trustees. If the trust is already created or is just created, he still has to familiarize himself with the trust instrument. He needs to know what his powers are, what his duties are, whether or not he needs to get consent from anyone, whether he has a fleet provision, what's the governing law of the trust. He needs to know who his beneficiaries are, where they are located. He needs to know the tax implications. He needs to look at the assets, determine whether or not he needs an advisor. He has to set up a strategy, and he needs an objective for the investments. So he also has a duty to administer the trust in accordance with the terms of the trust instrument. So when you get your trust deed, look at these duties, and then you will see how, when you read the provisions, you'll see exactly how the trustee has these duties. He also has to act in a fair and impartial way to the beneficiaries. That means he must treat all of them equally, and he has to be fair. So even though he's not under duty to distribute income or capital, he has to consider whether to distribute income or capital on a regular basis. He has to keep trust accounts. He has to provide the beneficiaries with information in accordance with the trust instrument and applicable trust law, because information is provided under Section 83 of the Trustee Act. He has to exercise reasonable care and skill in the administration and management of the trust. So that means that when he is carrying out his duties and managing and administrating the assets of the trust, if he needs to seek professional opinion, then he needs to request it. But that doesn't obligate from his duties to actually know what is happening with the trust assets. He has to invest in investments that are authorized by the trust instrument. And we'll get to that later when we do the chapter on investments. So that means that in the trust instrument, it may actually stipulate what he can and cannot invest in. And then his investment strategy and objective has to be tailored towards the beneficiaries. So he had to look at their ages. He had to look at what the settlor would wish for him to invest in based upon if there are any restrictions in the trust deed. He has to protect and preserve the trust property from unnecessary loss. So that means that if he is going to sell a piece of asset, then he has to make sure he gets the proper documentation to say how much the property is worth. And of course, he cannot sell to himself unless he's gotten the permission from the beneficiaries. He has to act in good faith and always what's in the best interest of the trust. And last but not least, he cannot make any secret profit. So like I say, he can delegate certain duties to other persons if the trust instrument allows. If the trust instrument is silent, then he refers to the Trustee Act. He cannot delegate his discretionary powers to distribute to a beneficiary. And he may be liable for loss suffered by the trust due to reckless and negligent actions of any agent or any firm that he has delegated a duty to. And that means that when he appoints agents on his behalf, he has to properly select that person. And he also has to supervise them. And supervising means that he must get reports from them and analyze those reports. Because he must always act in the best interest of the trust. Any questions there? So the next is the beneficiaries. So the beneficiaries are those persons who have the equitable interest and who have the right to sue. And the trustee acts on their behalf. And remember, the settlor may be a beneficiary. So a beneficiary could just be my son, my daughter, my siblings, or it could be my children, my grandchildren, my nephews, my nieces, my brothers, my sisters. Or it could just be a class of beneficiaries, my heirs. Now, when a beneficiary has an interest, that interest can either be vested or contingent. And vested means that the beneficiary has or is already in possession, or they will come to possession in the future. If the interest is dependent on the occurrence of a future event, then that event must be certain. For example, the death of another person. The death is a certainty. A contingent interest is one that is dependent on an event that is not certain to occur. So a contingent event may be a beneficiary reaching a certain age. That is not certain. So the beneficiary may die before reaching that age. So there's no certainty. So the interest may be contrasted to the vested interest, which is dependent on the death of another person. And the beneficiary's interest is based on a certainty and not a contingency. So you see that term used a lot when it comes to trust, whether the person had a vested interest or a contingent interest. So as a beneficiary with the equitable interest, you have certain rights. And one of those main or principal rights is the right to information. And that's information regarding the trust. Later down, you study in detail Section 83 of the Trustee Act, and that gives the beneficiaries of Bahamian Trust the right to specific information. One right is the right regarding production and receipt of trust accounts when requested. The beneficiaries have the right to inspect trust accounts and demand and under common law, they could ask for certain copies of documents if they're prepared to pay for them. So under our Trustee Act, beneficiaries are not allowed to obtain information on the deliberations of the trust and demand minutes of meetings. They can demand correspondence of the cannot see anything to do with how the trustee deliberated and exercising their discretion. And that's because you don't want one trustee, one beneficiary challenging the trustee as to why beneficiary A got 20,000 and they got 10,000. Because one, they will use whatever information that they're able to.
Miss Archer, you're going in and out. I can't hear you.
Additionally, beneficiaries have the sole and exclusive right to sue
Sorry,
trustees
Ms.
for abbreviation of breach of trust.
Ms. Archer, you're going in and out. So that piece that you spoke about,
Oh,
just
Lord, not again.
I couldn't hear
Go ahead, what'd
anything.
you say?
I couldn't
When?
hear anything. You went out just for a minute.
When? Which part?
After you were talking about right to inspect accounts, you were glitching in and out.
Oh, okay. So, all right. So let me just, I'll go up. So a beneficiary by statute and common law, remember common law means case law, they have the right to information on the trust. Under Section 83 of the Trustee Act, it sets out what information a beneficiary has access to. One of information is regarding production and receipt of trust accounts. So when a beneficiary requests to see the accounting of the assets of the trust, the trustee has to provide it. The beneficiaries also have the right to inspect the trust accounts and ask information on how the assets were invested or how they're being administered. Now, if they want copies, under common law, it says that they have to pay for it. Now, of course, the trustee can say otherwise. Now, a beneficiary cannot see information with regard to deliberations of the trustees. So that means they can't see minutes. They cannot look at the reasoning that the trustees made as to whether or not they're paying income and capital and how much they paid. And that's because you don't want one beneficiary deciding to sue the trustees because their brother or sister or cousin or auntie received more funds than they thought they should have. So as a beneficiary, you know that you have the sole and exclusive right to sue for breach of trust. But be mindful that under the Act, the trustees can insure themselves from the trust fund for any legal action, except for breach of trust. Because remember that breach of trust is directed at the trustees themselves, because they're the beneficiaries are challenging them that they did not administer and manage the assets for the benefit of the trust as a whole, or they didn't preserve and protect the assets of the trust, or they made secret profits to the detriment of the trust. Now, even though they have an equitable interest in the trust, and even though they have the right to sue, they cannot tell the trustees how to administer or operate the trust. But, like we said in the last class, they have the ability to terminate the trust or compel the vesting in the trust under the rule in Sanders versus Vautier. And remember now, in Sanders versus Vautier, the rule is what? They all must be sui juris, and they all have to agree to terminate the trust. So if they are all sui juris and they all agree to terminate the trust, then the trust property could be distributed to the beneficiaries in accordance with the provisions in the trust instrument. Any questions? Yes, no? Janice, that was better?
It was better for me.
Okay, all right.
All right.
All right, so now let's go to Unit 3. Unit 3 speaks about classifications of trust, because next week we're going to go more into case law. And so you would have your trust deed by then and had an opportunity to apply what we have done so far to the trust deed, because I want you to be able to refer to the trust instrument and refer to the Trustee Act. Did everyone have an opportunity to begin to read it? The Trustee Act.
I started it.
Started.
Okay. So you could see, based on what we have covered so far, that there are certain sections in the Act that you need to read and become familiar with. So if you have your Act handy, or you can make your notes, you have to read part 2, which is on investments. That's sections 4 through 13. So when we spoke about the trustee and the trustee exercising his powers, I said to you that there are powers in the trustee. So when you get your trustee, you're going to see that there are clauses that speak to his powers to do certain things. There are also powers in the Trustee Act, and that's part 3. And part 3 sets out all of the powers of a trustee. Section 14 speaks of his powers regarding land, the powers of trustees for sale to sell by auction, the power to sell subject to depreciatory conditions, which means that say if the asset is deteriorating, the power to postpone sale, trust for sale of mortgage property where a right of redemption is barred, the power of trustees to give receipts, the power to compound liabilities, the power to raise money by sale, mortgage, or otherwise, the protection of purchasers and mortgages and mortgagees, devolution of powers of trustees, the power to insure. Remember, I just mentioned that to you, that they can insure themselves except against breach of trust. The application of insurance money, where the policy kept under trust, power, or obligation. The deposit of documents and chattels for safe custody. Revisionary interest, valuations, and audit. The power to concur with others. The power to employ agents. And the power to delegate trusts. Protection against liability in respect of rents and covenants. Protection by means of advertisement. Protections in regard to notice. So when you look at these powers, there's certain ones of these, when you read the trust instrument, that will jump out at you. You know, the power to insure, as we just spoke about that one. That's section 24. The power to employ agents, section 30. So it depends on what the trustee has to do. There are certain powers. Now, further down, when you start speaking about the beneficiaries and based on the age of the beneficiary, or whether the beneficiary has limitations, then sections 37 to 40 comes in. And that's the power to apply income to maintenance and to accumulate surplus income during a minority. Which means that when someone is in a minority under the age of 18, instead of paying them income from the assets, you can accumulate it and pay it at a later date. Further down, on part 4, it speaks about appointment and discharge of trustees. So section 41 is one that you must read, that talks about how many trustees can actually administer one trust. It speaks about appointing new trustees. It speaks at section 46 about retirement of trustees, where there is no new appointment. And it also speaks in section 47 about of vesting of the trust property in new or continuing trustees. So if there is new trustees to be appointed, of course, there's always the court that you can go to in section 48, and in 49 gives the powers of new trustees appointed by the court. So when we spoke about the trustee himself and carrying out his duties and obligations, and remember, he has a fiduciary duty to the beneficiaries. I said that they cannot be remunerated unless provision is made in the trust deed. Now, if there is no provision and the trustee feels that he should be paid, then there's section 50. So that's one you should read. We'll leave the vesting orders. And let's move to part 6. It speaks to special provisions. Section 80 speaks to trustees to act in majority. 81 speaks to the protector of the trust. 83 speaks to disclosure of information to beneficiaries. 86 speaks to the power to continue to accumulate income. 87 speaks to termination and modification by beneficiaries. 89 is apportionment between capital and income. And of course, if you go under part 7, it speaks about the exemptions from exchange control, registration, and tax. So who got at least as far as investments in part 2? Anyone?
I did.
No? You did?
Yeah.
Okay, so when you get the trust deed, since you've read it, look at the trust deed and see how it is worded in terms of what they expect the trustee to do in terms of investments. And sometimes you'll see it more or less mirrors it.
Could you repeat what part 7 was to read?
Okay, part 7, hold on. Part 7, section 93, exemption from tax, exemption from registry, exemption from exchange control regulations. Let me see if I want you to read 92. Yeah, read 92 also. Trust duty. And at the very end of the act, it actually gives you trust provisions. So if you were to establish, you are drawing up a trust, it gives you the provisions. The clauses are already there. Now remember, you're not memorizing these. You're familiarized, you're just getting familiar. So let's look at section 30. Recall I said that a trustee can employ agents. And when you look at the act, section 30 is very long. What it actually says is that a trustee or personal representative, you know who a personal representative is, right? Everybody knows? So a personal representative is the collective term for the person who is going to execute or carry out the deceased person's wishes, either in a will or according to the law of inheritance. So collectively, they're called personal representatives. And it says instead of acting personally, they can employ an agent. And that agent could be an attorney, a counsel, another lawyer in another jurisdiction, a banker, a stockbroker, investment advisor, investment manager, or any person who is going to give them advice, or whoever's going to transact the business or do anything that's required to execute the trust or administer the trust. And then what the section actually does is it sets out what the trustee can do. And they have to carry this power to employ the agents based on the power that was given to them. And it say if you're appointing certain persons like an attorney, what's required? And the same thing for if you're appointing a lawyer. And under subsection 6 of that same section 30, it also says that a trustee has to take reasonable efforts to satisfy themselves that the agent has knowledge, appropriate knowledge, experience, and integrity. And if they actually carry out the measures to ensure that the agent that they're hiring has the qualifications and the experience and integrity, then there's less chances of them being sued for breach of trust or for any loss because of the appointment of that agent. And then the second requirement when you appoint an agent is you have to keep yourself informed. So that means that that agent has to be sending you reports, which have to be reviewed and noted that you've reviewed it. And this whole section on employing agent is always subject to what's in the trust instrument. Because if what's in the trust instrument is contrary to this section of the act, then what's in the trust instrument applies. So that's if they want to employ an agent.
So then you only consult the act if it's not in the agreement.
Agreed.
The trust, okay.
Yes. So that's why I want you, when you get the trust deed, to read the trust deed, and then you begin to understand, okay, this is what the trustee can, when you read the trust deed as a trustee, and then read it again as a beneficiary. Because it's separate roles. And then you begin to understand how the act applies. So it's going to take time because you're going to do it over the duration of this course, part 1. But once you familiarize yourself in the way in which a trust deed is written, what the provisions mean, and how the trustee act can be applied in the silence, or when you can go to the court for certain matters, then you begin to understand this whole trust arrangement. So, go ahead.
Gotcha.
Mhm.
Sorry, I have a question.
Go ahead.
At the onset of does the beneficiary get a copy of the trust deed also, or they can get that?
Yes, they can get that. But when you read it, let me know next class if you were a beneficiary, if you would understand what it means.
Okay.
You could get it, but you will see, I won't say nothing. I'll wait till you come back and let me know. As a beneficiary, if you'll understand what it means. Anybody else with a question? Okay, so remember I said that there are many different types of trusts. And the type of trust is not written on the actual trust instrument or trust deed. You know it by the wording or by the powers that are given to the trustee. So there are different types of trusts in terms of categories. So you have what is called a express trust, and you can have a resulting trust. Express and presumed resulting trusts, they are created by the express intention of the settlor. Remember, law is always about intention, what's in the mind. Then you have constructive and automatic resulting trusts, and those arise by law. So when you talk about express trust, you can have a simple trust, or sometimes it's referred to as a bare trust. A simple trust means that the trustee doesn't have any duty. And meaning having no duty means that there's no duty stated. But we know that by law, once you are a trustee, you have a fiduciary duty. So the law imposes a duty on you automatically. So if I say I leave all my assets to Amy to hold on trust for Benjamin, a simple trust that's being created. There's a duty that arises by law. Notice that in that statement, I don't state a duty to Adam to do anything. He's just holding it. But by law, he has a duty. A special trust states the trustee's duties. So the example I give you in the book is $5,000 to Angela on trust to pay the income to Betty or Cindy at her discretion. So the duty is to what? To pay. And then she also has to exercise her discretion. That means she can, or she may decide not to pay them. And she has to have a reason why. But she doesn't have to disclose it to them. So a statutory duty, these are created or implied by statute. So when a person dies without a will, their property vests in the personal representative. If the land is conveyed to persons in undivided shares, it will vest in the first 4 named persons. Makes a declaration that certain property is to be held in trust for certain persons.
Could you repeat that again, please? You went out the first 4.
Oh, that part. Okay. A statutory trust are created or implied by statute. So when a person dies intestate, the property vests in the personal representative. Or when land is conveyed to persons in undivided shares, it vests in the first 4 named persons. Because by law, it cannot be more than 4. An express trust is where the settlor makes a declaration that certain property is to be held in trust for certain persons. So this is like when a person goes into a trust company and state deeds, list all of their assets. These are my assets. And I want these in the trust. And that's normally an express trust.
Hi, Ms. Aja.
Go ahead.
Just one quick question. For the statutory trust, you said the land can only be conveyed, it cannot be conveyed to more than 4 persons.
Yes.
So if a person have, let's say, 5 kids, how does that work?
Only 4.
Still only 4. Okay.
So give me an example. Give me an example in your mind. What you thinking?
Example of what? I'm just
Of
trying to understand, like, how would they be able to, like, treat everybody fairly who you want to benefit from the land? So in that case, we will have to use a willing and not a trust. Or how do you?
I try and see how the best to answer you. Keep talking.
Or use another type of trust?
No,
I'm asking.
no,
Mhm.
no.
Mhm.
That part about the first 4 named persons, it depends on how you word it. That 4 named persons refers to whether or not the property is divided, or whether the property is tenants in common or joint tenancy. So
I have a question. When you say for the name persons, these persons will be named where, in which document?
it could be in the will.
Okay.
So when they say undivided shares, you know what that means, right?
A piece of property that you didn't allocate to certain persons. It was just there for everybody.
Right. So I didn't say give Melissa 10%. Give this one, well, I didn't say give Melissa 25%. Give Janice 25%. No. I just say it's for everybody. And if you say that, it's only the first 4. And that's how the law of equity works. It's the first 4.
Ms. Archer, so they could have had like, in that, the trust, it could say something like the class of, he could have said something like the class of my grandchildren for this land, that, he could have said something like that too? Or would it work in that case?
It depends. It depends of what you're going to do with the property. If the property is going to be for my grandchildren, right? Now it's to be decided whether or not you're setting up a trust and for whom. Because if you say my grandchildren, that leaves it just open. It can only vest in 4 by law. Because you know, tenancy, when one person dies, the ownership then goes to the remaining persons. Okay, let me let you make some notes.
Could you repeat that?
No, I can let you make some notes so you could understand, because you're going to move out of trust now and equity to land. A little bit about equity and land together. So when you speak about land itself, land is either in joint tenancy or tenancy in common. So joint tenancy is where two or more persons each own the whole interest in the land. You don't have no separate or distinct shares. And that means that none of them have exclusive possession. They can't say they own all, and they can't say they own a part. Because with joint tenancy comes right of survivorship, what I just told you. When one person die, okay, so say Janice and Melissa own this property in joint tenancy. If one dies, the next one owns all of it. So in joint tenancy, there can be more than 4 legal joint tenants. Because in land law, you don't own land. Your ownership means possession. And possession means that you have exclusive rights over that land. Now, if a land is tenancy in common, then you own the land jointly, but in undivided shares. So that means that each person has a share in the land, which may be equal or unequal. It don't have to be 50-50. It can be 60-40, 70-30. And when you have tenancy in common, there is no right of survivorship. So if one party was to pass away, the personal representative of that party then sees to where that property is supposed to go. That's the difference between the two. So it says that where the land is conveyed to persons in undivided shares, it will vest only in the first 4. No more. Is it clearer than mud now? Yes, no?
When we say when we say personal representative, does that also mean like an executive of the estate?
Right. So personal representative, remember, I said that's the collective word for meaning either an executor if the person left a will, or an administrator if they didn't leave a will. It's the difference between the two. But collectively, you just call them personal representative. That's it. So remember now, when you read the Trustee Act, you will see the Trustee Act speaks to trustees and personal representatives. So it's referring to persons who walk in a trust company and incorporate a trust, and persons who would have created a trust within their will. All of that is covered under the Trustee Act. Any more questions before we move on? No questions is silly questions, so just ask.
How do you create a trust within a will? I don't understand that concept.
Okay, so in a will, you would start out by saying, this is my last will and testament. and this revokes any previous wills. Then you would say, I appoint so-and-so as my executor. Then you would say, if you wish to, you could actually give instructions as to how you wish your remains to be disposed of. Then you go through and make a list of how you want your property to be disposed. So you could begin by saying who you're giving outright gifts to. I hereby bequeath my shoe collection to so-and-so. I hereby bequeath my clothing to so-and-so. I hereby bequeath my jewelry to so-and-so. Or you could say, I hereby devise my property lot number so-and-so to whomever. I hereby devise my property in Abaco, whatever key, lot number so-and-so to whomever. Or you could say, I hereby request that the below assets be placed in trust for the benefit of my 2 children, Mary and Sam, for the duration of their life, and then to their children and grandchildren. And then you list the assets. So you've created a trust. So the personal representative, when you die, then has to go and have a proper trust constituted and have the assets transferred to the trustee for the benefit of the 2 children and their successor children.
And is that because they are minors? And you basically want to make sure that the kids get it and not their guardians?
Anyway, you could do it anyway. The children may not have even come yet, the grandchildren. So you're leaving it to the children. If you wanted to put it in trust just for minors, you can do that. The trust doesn't have to be created because they are minors. You could create the trust for adults. It's just that you want someone else to manage the assets. So it has to be assets that are manageable. And when I say manageable, it means that they have to administer it and manage it to a point whereby it is generating income. So whatever assets it is has to generate an income. So let's just say this person has about four sets of condominiums. They also have a shop. So they would create a will and put a trust within it because they need someone to manage that property and just pay out the income every quarter or half a year to the beneficiaries. But the trustee's duty would be to manage that, preserve and protect those assets. Clara?
Yes, that's clear. Thank you.
Okay, no more questions? Ask questions. If you're not clear, ask. All right, so another type of trust is an executed or executory trust. An executed trust is one where all of the necessary signage, all documents, everything that needs to, I guess, complete the settler's intentions have been expressed. So the settler of an executory trust is where the settler declares an intention to create a trust. But he hasn't stated what his interests or what interests he wants for the beneficiaries. A completely or incompletely constituted trust is where the settlor has made his declaration that he wants to convey the property or make himself a trustee. And then he follows the formalities and transfers the property. An incompletely constituted trust is where it could be proven that the trust was created to defraud creditors. And the settlor didn't have the requisite capacity. And that's normally, they're saying, even though it has been a completely constituted trust, because it was settled to defraud, then the issues arise as to whether it was actually completely constituted. And then the trust may be considered to be void. If you say you're going to create a trust and there is no property transferred, then of course you know that the trust is not constituted. For a trust to be properly constituted, you have to transfer the property. Otherwise, there is no trust. Now, in last class, we spoke about the maxim. Equity will not assist a volunteer. And someone was asking me, what is a volunteer? And remember, I said that I would find a case to see if I could explain it as simply as I can. So a volunteer means someone who wants to sue a trust, but hasn't given any consideration for that trust. So do you understand me when I say consideration?
So can you repeat the definition again? Someone who wants to sue a trust but hasn't given any consideration?
Yes. And I asked you,
Okay.
understand what consideration means? Yes?
Something
No.
tangible, like they didn't provide property or whatever?
Yeah, money.
Okay.
Yeah, okay. So you normally see this maxim being used in family settlements, where the person who covenant, that means the person who said that they were going to create this trust, failed to settle the trust or even establish a trust. So even after they would have acquired property, they still failed to settle the trust. And so what the maxim of equity is saying is that volunteers cannot enforce such a covenant, which means that if you did not give any consideration towards the settlement, then you cannot come to the court to say you are going to sue the trustees because certain properties are not included within this trust. So in the case of Pulmacher's settlement, this was in 1841, a husband and wife on their marriage, they covenant with their trustees to settle the wife's after acquired property for the benefit of herself. So that means that they had made an agreement with their trustees that any property that the wife acquired after they got married, that was for her benefit, she would have it for the benefit of both of them, her and her husband. And after that, it would be for her next of kin. So the husband purchased some stock in the wife's name, and the wife later sold it and invested the proceeds in another stock. She died without any children, and her husband became the administrator of the estate. So her family, her next of kin, as her brothers and her sisters, they wanted to bring an action. And the husband couldn't enforce the proceeds from the sale And so at the end, none of them were able to claim. The husband, because he was statute barred, and her next of kin, because they were only volunteers. They didn't give any consideration for that settlement. So they couldn't bring an action to say that the proceeds from that belonged to them. So that's where the maxim comes in, that equity will not assist the volunteer. Private and public trusts. It means that a trust can be created for a particular purpose. An express trust could be an express trust that is a private trust, could be for the benefit of just certain individuals or class of beneficiaries. And a public trust is one that is for public benefit, for the welfare of the public, such as a charitable trust. Discretionary trust is where the trustees will be exercising his discretion as to whether to make a payment of income or capital to certain beneficiaries. A fixed trust is where the trust stipulates the amount that the beneficiaries are going to receive. In a fixed trust, the trustees have no power to alter or withhold the interest unless it's required by law. And by law means that there could be tax implications. A protective trust is to prevent a beneficiary from disposing of any or all of his beneficial interests. And normally these protective trusts are for wastrels, beneficiaries who waste or spend a lot of money. So it's just to protect them. The other trust type of trust is a secret trust. And the secret trust can be fully secret or half secret. A fully secret trust, it would appear in the will as an absolute gift to a beneficiary. So I hereby bequeath the sum of $50,000 to Adam. That is, it doesn't appear on the face of the will that the testator tells the legatee the purpose of the trust outside of the will. So the money is not really for Adam. The testator would have said, Adam, I'm giving you this money, but this money is support my daughter, Mary, who lives somewhere else around the world. The testator have to communicate the fact that the property is subject to a fully secret trust to Adam under the will. And he can tell Adam about this anytime during his lifetime, that I have put you in my will and the purpose why he put him there. So it doesn't matter of the date of the will, as long as during his lifetime, he tells him, I have made provisions for you in my will, and those funds are for you to take care of my daughter or my son. And he has to, the testator has to communicate that he is a legal binding obligation. It's not a moral one, which means that Adam can decide after the testator died that, well, you know, he left $50,000 for Mary, but I give Mary 5 and keep that another 45. No, it is a legally binding obligation. And whatever terms and conditions that the testator stipulates is what the legatee must follow.
How will they know though?
Who?
So let's just say, for example, Adam was told by the testator dies. It may be a legal binding document, but the secret is the daughter, right? So
Yes.
does the daughter know? And how
No.
will they know that they're taking care of the daughter?
They don't. That's why it's telling you that Adam, he has to accept that he is holding assets in a fully secret trust. He has a legal binding obligation. Let's just say the daughter doesn't know that it's 50,000. But the daughter may realize that, guess what? Every time daddy visited me or daddy sent something for me, he sent it with Adam. I am surprised that my daddy passed away and all of his assets, he did not mention me. And she could bring a matter against him for him to disclose. Let me see if I can find you a case. No, okay, this is a case out of the Caribbean case. The testator was the father of 2 daughters. And the appellant in this case was being the elder, and the respondent was the younger one. He was the owner of several properties, one of which, known as lot number 21, he had transferred to the appellant as an inter vivos gift. After the testator made his will, he obtained from the appellant a promise that she would transfer lot 21 to the younger daughter after his death, emphasizing that if she did not agree to do this, he would change his will. So relying on the appellant's promise, that's the older daughter promise, the testator refrained from making a new will. In the testator's will, the older daughter received substantial benefits, including a life interest in one of the testator's plantations and a half share in his residuary estate. The elder daughter repudiated her obligation to carry out the promise she had given to her daddy. And the court held that the daughter was guilty of fraud in refusing to honor her promise in reliance upon which her father had left his will unaltered. The daughter was bound in equity by a secret trust to transfer lot 21 to her sister. It was immaterial that the subject matter of the secret trust was not, as in the usual case, the testator's property, but that of the secret trustee herself. Now you see?
Yeah.
Yeah, so you could sue. So a half secret trust is, it appears as a trust in the will, but the details are revealed outside the will. So the conditions to be met for half secret trust are that the testator must communicate the half secret trust to the legatee before or contemporaneously with the making of the will. You see the difference between the two, right? Fully secret, he can tell it anytime during his lifetime. Doesn't depend on the date of the will. But for a half secret trust, he has to do it before or while he is making the will. And then similar to a fully secret trust, all the terms must be communicated and it must be legally binding obligation. A charitable trust. Go ahead. Someone have a question.
Yeah. So let's just say the secret child, nobody knows about the secret child, right? And they know, okay, that whoever has money, the parent has money, but nothing was left in secret or in partial secret. Could they still go after anything, any assets?
No, they're not going to go after any assets. They then have to go to the court to bring an action against persons who would have been given certain gifts.
So they have to go after
ascertain
the
whether anything,
beneficiaries.
they have to go and see whether there was any legally binding obligation behind any one of those persons.
Hmm.
Mm-hmm. So let me give you a little bit about this other case. Ottaway versus Norman. The obligation undertaken by the secret trustee was to dispose of the property by her will in favor of the secret beneficiary. The facts were that the testator had lived in his home with a woman called Eva, who had formerly been his housekeeper. The testator devised the house and its contents absolutely to Eva, but they had agreed privately that Eva would devise the house by her will in favor of the plaintiff, who was the testator's son. On Eva's death, it was found that, contrary to the undertaking she had given, she had left the property to the defendants. The question whether the house was held on a fully secret trust for the son or whether it passed to the defendants under Eva's will. So you see what Eva did, right? Eva had an agreement and she was supposed to dispose in her will the property to the owner's son, but she instead passed it on to her family. The judge held that the secret trust doctrine applied. He said the secret trustee, referred to as the primary donee, had not agreed to hold the property on an immediate trust for the plaintiff, but only to dispose of it to the plaintiff by her will. But it was nevertheless within the secret trust doctrine, the basis of which was the obligation imposed on the conscience of the secret trustee and the machinery by which the testator intended the obligation to be carried out was immaterial. And so again, he said that there was no question of fraud because the secret trustee Eva was not claiming an absolute interest for herself. The competition was between the secret beneficiary and the beneficiaries under Eva's will. So that's fully secret and half secret. Now, charitable trust, as you know, is created for the promotion towards the community in some way. And they are enforceable by the Attorney General on behalf of the government of the Bahamas. And a charitable trust is different from a private trust, because a private trust is benefit defined persons. A charitable trust has objects. A charitable trust doesn't fail for uncertainty of objects. But in order to qualify as a charitable trust, it has to be for charitable purposes. And charitable trusts are not subject to the rule of perpetuity. Rule of perpetuity means that it has a certain length of time or happening of some uncertain event in the future. And most charitable trusts are exempt from income tax. So before the case of Premsel, a charitable trust was one that was for the relief of the aged, the impotent, and poor people, for maintenance of the sick and maimed soldiers and sailors, for maintenance of school and free school and scholars and universities, to repair bridges and ports and churches and highway, the education of orphans, support of tradesmen and handicapped men, and redemption of prisoners and captives. But with the case of Premsel instead, in that case, it decided that there are 4 heads of charity. One is for the relief of poverty. The second one is for the advancement of knowledge. The third one is for the advancement of poverty, the relief of poverty, advancement of education, advancement of religion, and for the beneficial, for the beneficial interest of all of the community. Now, besides a charitable trust, you can have a purpose trust. And a purpose trust is a subset of a private trust. And all it means is that the trust is set up for a particular purpose rather than beneficiaries. So in some instances, trusts will fail, which fail to be treated as purpose trusts arise as soon as seen failed attempts to attempt charitable trust. So whenever you talk about a purpose trust, because we have purpose trusts in the Bahamas, they're set up for a particular purpose. So let me give you an example. You can have a trust that's set up just to deal with asset recovery. So that's a purpose trust. Then you have implied and resulting trust. Resulting trusts arise from the presumed intention of the settlor. So an implied or resulting trust arise if the settlor created a trust, say for a life. Equity would presume that he intended the money should result to himself or to his estate on whatever the person is, the person's death. A presumed resulting trust arise where two or more parties have purchased property jointly or in the name of one person and have contributed in different proportions. So there'll be an implied understanding that all parties will have an equitable interest in the property. So that means that you put two persons purchase property together, one purchased it, but the other one may have made some other contributions towards that property. And so the law says that there is an implied understanding between the parties that they would have an equitable interest in the property together. It doesn't have to be 50-50, it could be 60-40, it could be 70-30, but there is an interest in it. So where in the absence of evidence, the parties' intentions to voluntary transfer property from one person to another can give rise to a presumed interest. Because then it says that one party holds the property in favor of another. An automatic resulting trust arises by law. And it doesn't take into consideration the intention of the parties. So this is where a disposition is made by one party to another on trust, and it leaves some or all of the beneficial interest undisposed of. So that means that one party will hold the undisposed beneficial interest automatically on resulting trust for the other party. And resulting trusts, automatic resulting trusts do not arise where the property disposed of has requirements such as it has to be in the form of a deed. A quis-closed trust is a trust where a person transferred property or funds to another person for a specific purpose. And it creates a trust relationship between the two parties. So this is where a person goes to a bank, obtains a loan, and the purpose for the funds that are credited to the account is for the mortgage or a mortgage, or to pay for a particular contract of goods coming in. Or it is funds, a loan that has been granted to pay off the proceeds of a loan at another entity. So that means that the client cannot withdraw from those funds. And because the bank is aware, based on the communication that it received, that those funds are designated for a particular purpose, then a trust relationship arises between the two parties. So that means that if the person to whom the funds were earmarked for then comes for their funds and find out that the client has used those funds, that party can sue the bank along with the client for those funds. And that's called a quis trust. A constructive trust arises by law, by the courts, and it's a remedy for where one party makes it unjust if he was to maintain the whole or part of a beneficial interest in the property. So a constructive trusts are imposed irrespective of intention. And an intention can be expressed or can be implied. So constructive trust appears to be to preserve property rights affected by unconscionable conduct on persons considered to be constructive trustee. So a trustee who tries to make a secret profit from his fiduciary position, those funds that he receives, he holds them as a constructive trustee. And then I gave you the case here of Boardman versus Phipps. Again, this was a company, and the shares that the directors purchased, they were held as a constructive trustee for the benefit of the beneficiaries. Be mindful that constructive trustees are not subject to the same duties as an express trustee. And they don't have any powers. Constructive trustee really means is that the person is holding assets that is for the benefit of the beneficiaries. And so his aim is just to recover the trust property from the trustees or trace the property if the trustees have disposed of it. Another type of trust is a sham trust. And a sham trust means that a trust is not a trust. You normally see sham trust when either the settlor has too much control over the trust. And so the trustee is not managing and administering the trust, it's actually the settlor. Or it could be considered a sham trust when creditors are behind the settlor, saying that the trust was established in order to avoid paying credits. So in Raman's case, which is a good case for you to read, the settler's behavior in aggressively and unilaterally dealing with trust assets and investments as he pleased, and the trustee's behavior in allowing him to do so, subsequent to the creation of the trust, led the court to decide that the trust was a sham because the trustee doing. And then I set out for you what Justice Diplock had to say in the case in Snook versus London and West Riding. He said, I apprehend that if it has any meaning in law, a sham means acts done or documents executed by the parties to the sham, which are intended by them to give to third parties or to the court the appearance of creating between the parties legal rights and obligations, different from the actual legal rights and obligations, if any, which the parties intend to create. The one thing I think is clear in legal principle, morality and the authorities, is that for acts or documents to be a sham, with whatever legal consequences follow from this, all the parties thereto must have a common intention that the acts or documents that are not to create the legal rights and obligations which they give the appearance of creating. No unexpressed intentions of a shammer affect the rights of a party whom he deceived. So it was also stated that the conceptual basis for the sham doctrine lies in the court's ability to see through the acts or documents which are intended as a facade or a disguise. They're designed to conceal the real truth of the matter by the settlers, the trustees, and or their advisors, particularly in offshore revocable trusts, which are susceptible to legal scrutiny when it comes to sham trusts. So you see the tax authority in the United States normally go behind trusts, which they consider to be shams when the settlor has outstanding tax obligations to the US authority. So courts will often review and analyze the subjective intentions of the parties to a trust transaction. And one of the key elements in the analysis is to determine whether all the parties to the transaction had the requisite intention to mislead third parties. So what the courts do is they scrutinize the conduct of the parties, especially the settler's retention of certain powers and his control and dominance over the decision-making and actions of the trustees and the trust assets. So in the Rahman case, Mr. Rahman retained control over the trust funds during his lifetime. And so the trust itself was considered to be a sham. They said that the trustee was never made master of the assets, which means that he never exercised his power to manage and administer those trust assets. So, as in most legal matters, he who asserts must prove. So if you are going to say that a trust is a sham trust, then you have to be able to point out why you've come to that assertion that the trust is a sham. And that is their challenge. They have to prove that. And it all is on a balance of probabilities. Any questions? No? Yes? If there are no questions, I need you to continue your review of the Trustee Act. You should get your copy of the trust instrument so you can read it in conjunction with the Trustee Act. And for next week, you have to read chapters 4 and 5. So chapter 4 is on the validity of trust. And chapter 5 is on appointment of trustees. So validity of the trust is case law, and appointment of trustees, of course, you're going to refer to the Trustee Act. Any questions? No? Janice, you have a question?
Now, you had mentioned that you were going to provide us, I guess, with some questions for short answers or something.
Yes, I will email it to you. Not yet.
Oh, okay, okay.
I think I'll do it after. I think I'll do it after validity of trust.
Oh, okay, all right, cool.
Yeah. Because the one on classifications of trust, I could send you 2 or 3 of those. But the validity of the trust is maybe more difficult.
Okay.
So
all right,
what I'll
no
do is
problem.
I'll combine 3 and 4 together.
Okay,
Okay, so since you didn't get the trust instrument, I give you time to read that and do the comparison. Read chapters 4 and 5, and then when I send the homework, I want to see how you approach it, because I would expect that you either going to refer to the trust deed itself, or you're going to refer to the Trustee Act and bringing your answers together along with case law.
okay, all right, thanks.
Okay, all right.
Mhm.
So I don't want to cram you up too quickly. Let me give everybody a chance to read, since only one person seemed to have gotten, like quarter way through. Because I know you're working, so I don't want to push it too much. But next week, after next week class, you will get some questions to do. So next week is my last class with you, but once you send it in, I will mark it and send it back to you.
Can you please just touch bases with the office, like by Wednesday, to ensure that they
Yeah,
sent
I
the
will.
stuff?
Yeah,
Okay.
I will. I made sure that they got it, but I thought
Okay.
that they sent it out, so I'll make sure.
All right,
I'll
thanks.
see if they could send it out. If not, if they don't have it on the system today, that they send it out on Monday. So it gives you sufficient time each day to look at it and go through it. So I'll make sure that happens. All right. Any other comments? I didn't get an answer.
So the homework is just to go over the deed and see how we would approach it as a beneficiary and as a trustee.
Yes, and make sure you continue reading the Trustee Act.
Okay.
And then read chapters 4 and 5.
5 and
Next week is the last class with me, but probably by Sunday, next week Sunday, I will send you some practice questions, maybe 2 or 3, just for you to get a feel, and you can send those back to me. And then if need be, depends on how you write, if need be, I will send you a note and say, we need to discuss. And then we'll have a conversation one-on-one. If need be. Okay?
Okay,
All right. So have a great weekend. You have time now to stretch your brain, relax, and go from there.
thank you.
It's a lot of information, right? So it's a lot of information. So if you didn't read from the beginning, from last class, take the opportunity to do that now, before what else you do for the rest of the day, and then read 4 and 5, because as you move on, you're gonna find out that is a lot of information. You're gonna start to panic and wonder how you're gonna pass this exam. So that's why I'm trying to tell you, you have to pace yourself. Okay? So enjoy your weekend. And if you have any questions as you reread, then you can always shoot me an email.
Can I get your email, please?
It's in the thing.
Oh, in the book? Oh, okay.
No, not in the book. It's in the email. When Miguel sends the link, all of us is in it. All of us.
Okay.
Nacho, you see it?
I see it, yes.
Okay, you're right. So just use that. And you'll get me. Okay?
Thank you.
Okay. All right. So have a good weekend.
You as well.
Okay. Bye-bye.
Bye.